Hello and welcome to today's presentation on U-Visa eligibility and a general overview of the U-Visa application process. My name is Whitney Stout and I am a staff attorney at South Carolina Legal Services and the Cultural Humility Unit Head. South Carolina Legal Services is a statewide law firm that provides civil legal services to protect the rights and represent the interests of low-income South Carolinians. So to apply for legal services, you can call our intake office, or you can apply online for many types of services. If you intend to put on an online application, you may do so at our website, and we also have a video on the South Carolina Legal Services website that includes best practices and tips for helping to make your online application a smoother process. If you are watching this presentation and you are a member of a community organization, a victim advocate, or another type of advocate in the community, using the online system is a good way to assist someone in submitting an application for services, because you can pull that up on your computer while the person that you're helping is in your office and help to make sure they include all of the relevant information rather than just giving them our phone number. So we do encourage you to take a look at that online application, as well as view that video on our YouTube channel about the online application process for tips, best practices, and more information on which types of legal issues are best covered by that online application process. Before we get started with today's presentation, I just want to emphasize that today's presentation is to provide general information and is not targeted legal advice. So I am not anyone's attorney that may be attending today, and attending this presentation, viewing this presentation, or applying does not automatically create an attorney-client relationship. To get started, what is a U-Visa? A U-Visa is a type of immigration relief that is a non-immigrant visa. What that means is when you're applying for a type of status with the United States, you have immigrant visas, which are visas that, if approved, grant you some sort of residency here in the United States. So typically lawful permanent residency, which is what some folks refer to as a green card, or in some cases citizenship. A non-immigrant visa is a type of immigration relief or application that gives you permission to be in the United States, but does not grant you permission to be in the United States permanently, nor does it grant you citizenship. So examples of non-immigrant visas are U visas, T visas for victims of human trafficking, and most types of employment visas are also non-immigrant visas, because these visas will, like I said, give you permission to be in the United States, sometimes work in the United States, but is not a document saying that you can continue to reside here permanently, and they usually do have an expiration date. Now, what makes a U visa unique in many aspects is that although a U visa is a non-immigrant visa, if you're approved for a U visa, it can be a pathway to that lawful permanent residency or that green card. U visas are for victims of crime, and they allow you to include your direct family members in the application. So we will go over more of these points as the presentation continues. So eligibility for a U visa. You must be a victim of a qualifying criminal activity. So this means criminal activity that falls into a certain category, not necessarily all crimes. So the list of those, they are typically crimes that would be considered felony offenses in the United States, such as abduction or kidnapping, sexual abuse, being held hostage, or things like fraud, blackmail, conspiracy, felonious assault, manslaughter, murder, obstruction of justice, prostitution, human trafficking, witness tampering, or something that is elevated to a more serious degree. Also included as a qualifying criminal activity is domestic violence. So even if the person that committed an act of domestic violence against you was charged with a crime that was not considered a felony, the act of domestic violence in and of itself is a qualifying criminal activity. So even if it was not a felony, domestic violence is still a qualifying crime. In some cases, things like stalking or threats or harassment may also be incidences of qualifying criminal activity if they were part of a greater pattern of domestic violence. You'll note that I also said manslaughter and murder as an example of a qualifying criminal activity. Clearly, if someone was murdered, they are not able to submit the application because they are no longer with us and are deceased. However, a derivative, which means a family member, particularly if that family member witnessed the murder or manslaughter, may be eligible to submit that application for themselves. In addition to the person being a victim of qualifying criminal activity, they must have suffered substantial physical or mental abuse or harm as a result of that crime. So this could be physical injuries, such as broken bones, wounds, gunshot wounds, stabbings, things of that nature, or it can be something mental and emotional. So this happens a lot, such as if you're a victim of armed robbery. Perhaps you were not the victim of a gunshot wound or a weapon wound, but you do suffer symptoms of anxiety, depression, or post-traumatic stress after you were a victim of that incident. Another time that mental and emotional abuse comes into play is when we're talking about victims of domestic violence. So domestic violence is unique in the sense that domestic violence can often go on for a long period of time before somebody is able to or chooses to report that to law enforcement. So the incident that could get reported to law enforcement may be something like a threat or a harassing message or an event of physical violence that doesn't cause substantial harm. However, the United States government allows people to look at the entire pattern of abuse in the relationship. So even if the one incident that was reported to law enforcement did not result in substantial physical or mental harm or abuse, if you are able to show that the pattern of abuse across the entire relationship caused lasting emotional or mental harm, or that there were other incidences of physical abuse during the relationship that did cause substantial harm, someone may still meet the qualifications for that particular element of the visa. The other part to it is that you must have information about the criminal activity, and you must have been helpful, or likely to be helpful to law enforcement in the prosecution of the crime. So what this means is that not only were you the victim of crime and you suffer that substantial physical or mental harm, but that you also reported this to law enforcement and were ready and available to answer their questions, serve as a witness, or assist them in any way that they required during the investigation of that crime against you. The crime had to have occurred in the United States of America and violated the laws of the United States of America. The visa does allow you to petition for direct family members. You have to obtain something that's called the I-918 Supplement B, which I'm going to talk about more in great detail in just a moment. But that means that law enforcement is willing to certify and verify that you meet the above elements, and you must be what's called admissible to the United States. Admissibility is not something that I'm going to go into great detail in during this presentation because it's something that you really should have an immigration attorney evaluate based on your specific circumstance. But there are some people that are in the United States that for one reason or another are considered inadmissible, meaning that they are generally not eligible to apply for certain types of immigration relief because of something that they have done. So more frequently, if you entered the United States unlawfully and you were undocumented when you entered the United States, then you are likely considered inadmissible. However, when it comes to a U visa, there is actually a waiver for folks eligible for a U visa. So even if in the past you have been told that the fact that you entered the United States unlawfully or entered the United States and left and then re-entered again makes you ineligible or makes it so that you're not able to receive certain types of immigration benefits, when it comes to a U visa, that may not apply to you because there are exceptions for this type of visa. So the form I mentioned just a moment ago, the I-918 Supplement B, is a form that law enforcement must sign certifying that you were the victim of the crime, that the crime is one that qualifies you for a U visa, verifies that you were, are, or are going to be helpful in the prosecution of the crime, and sets all of that information out for immigration. Now, an official of a certifying law enforcement agency can be many different types of people, depending on the jurisdiction of the place that handled the investigation of the crime. So that could be the solicitor or the prosecuting attorney that assisted with the case. That could be the sheriff of that jurisdiction, or that could be the responding law enforcement officer or detective that investigated the case. So every county is going to handle this a little bit differently. Some areas of the United States, the law enforcement officials receive many applications for an I-918 Supplement B. So their office will have someone that is designated to review those requests and respond to those requests. So a good starting point is to simply call the prosecutor and solicitor's office and ask if they have someone there designated to sign, and call the local police department or the sheriff's office and ask if they have someone designated to sign. Now, some law enforcement offices across the United States are not particularly familiar with the U visa or these forms. So when you call, they may not be aware of what you're talking about or have familiarity with this. This is one reason why I recommend that you have an attorney assist you with this process, because a lawyer can assist with explaining to law enforcement what the form is and why you need that form. Another thing that you may want to explore is contacting the victim advocates of that area, because victim advocates are sometimes able to reach out on your behalf to find the right contact in the law enforcement agency or to advocate for you regarding why you need that form signed and why you are someone that law enforcement should want to support in that process. The reason that I suggest that you have an advocate to help you with this, preferably an attorney and maybe also a victim advocate, is because the law enforcement agencies have discretion regarding whether or not they sign these forms. So what that means is the federal government has left it up to the local jurisdictions to decide if this form should be signed. That means that there really isn't a way to force them to sign it. So even if you and your attorney find and believe that you qualify and that it's appropriate for them to sign it, if you can't make them do that. So that's one reason why it helps to make sure you identify whether or not there's an appropriate contact person there, and that if possible you have someone assist you with that process. Another caveat to this, and something to keep in mind, is that even if you get the form signed, the form is only good for 6 months. So that means if you get it signed and 6 months pass and your application hasn't been finished and turned in and sent to immigration, then you may have to ask for that form to get signed again. And sometimes you may have difficulty getting that done, depending on which office you're dealing with and how busy those law enforcement officials are. So when you begin this process to request this document from law enforcement, make sure that you have talked to your attorney or whoever is assisting you with the U visa, and make sure that you are prepared with all of the other documents and information that you're also going to need so that your U visa application can get submitted as quickly as possible after you obtain this certification from law enforcement. Without this certification from law enforcement, you cannot proceed with the U visa process. So it's extremely important that you have this form. Some attorneys will make this the very first step of the case evaluation process before they begin asking you for very much other information, because without this form, like I said, you cannot proceed. So if you're able to get the certification form signed, you will have to support your application with additional evidence. So again, this is another reason I recommend that you have an attorney represent you in the preparation and filing of your application. Because if you go online and you go to uscis.gov, which is the government's website that has the immigration forms, they'll tell you the forms that you need to submit. But you also have to basically prove your case. You have to provide evidence to the federal government and to this agency that you meet the qualifications of the visa. So you have to submit those forms that are listed. The form I-918, which is your petition for a U visa. The Supplement B, which is the certification from law enforcement I just discussed. And if you are applying for any family members, you also have to submit the I-918 Supplement A for each family member. And if you are inadmissible, you may have to submit the I-192 application for advance permission to enter. So what that is, in a sense, is a form that you submit saying, I understand that I am typically what's called inadmissible because of the following reasons, and I am submitting an application for you to basically look past those and grant my visa. And this form in particular is one that you don't necessarily need an attorney for, because you can submit these forms without a lawyer, but it is not recommended because inadmissibility, like I said, can be a very complicated thing, and you want to make sure that somebody has looked through those factors and made sure that you qualify for all of this. If you are inadmissible, it makes it more likely that if your application is denied, that you're going to be referred for removal or deportation. In addition to the forms that you have to submit, you need to submit a personal statement, which is like an affidavit that tells your side of the story about what happened when you were a victim of the crime, explains how you suffered that harm, how you were helpful to law enforcement, and we also recommend that you include a statement about why it is that you want to continue living in the United States. So even though you have the certification form from law enforcement verifying that you meet these factors, your personal statement serves as your personal story testifying as to what happened and providing those details. If you have an attorney or an advocate helping you with this, they can help make sure that you include all of the relevant information in this document. You also may need to submit evidence of the crime, such as police reports, in addition to the I-918, and evidence of substantial harm. So in addition to the statement from law enforcement and your personal statement, it's recommended that you provide additional things to show the harm you suffered. So this could be photos of any wounds, hospital and medical reports, a note from a victim advocacy agency confirming that you were the victim of domestic violence, something from a hospital or medical provider showing that you had to be placed on certain types of medication for PTSD or anxiety, or it could be something from your therapist or a victim advocate describing how they've seen you suffer harm. Something that you can also obtain are affidavits and statements from friends and family members who were either witnesses to the crime or who have firsthand knowledge of how the crime has affected you. So if you have a friend or a family member who can submit a sworn statement or an affidavit saying, this is how I saw this person change and how I saw them affected by this crime, that can also be additional evidence to support that substantial harm element. Qualifying family members are the people that you can include in your U visa application. So you must petition for qualifying family members at the same time that you submit your U visa. So this means that their forms must be included with yours. So if the person applying for the U visa is under the age of 21, they can apply for their spouse, their children, their parents, and their unmarried siblings that are under the age of 18. If the person applying for a U visa is 21 years old or older, you can include your spouse and your children in your U visa application. So again, this is another time where it's really helpful to have an attorney who can make sure that you include those family members. If you do not include those family members as part of the U visa application, then you may have to wait to apply for some status for them until you become a lawful permanent resident, which can make their wait for residency and work authorization much, much longer. So please make sure that if you're going to pursue a U visa, you are very clear on who you can apply for in your family at that same time. After an application is received by immigration, after you send your U visa application off, you will receive what's called a receipt notice back in the mail. So this receipt notice is basically going to assign you what's called an A number if you don't have one. So that is they call it an alien identification number. And this is an identification number that will be assigned to you, and each of your qualifying family members should receive a number as well. There will also be a receipt notice number that you can use to look up the status of your application. After your application is received, you may receive something that's called a request for evidence, or an RFE. So what that means is that whoever was assigned your packet to review was looking through your application and would like additional evidence about one of the factors. So it is extremely important that you keep your address updated and accurate with immigration and with your attorney. Because often when those requests for evidences are sent, you may have as little as 2 weeks to obtain additional evidence and return it. So you do not want there to be a delay in you or your attorney receiving that document. Something to keep in mind is that only 10,000 U visas can be approved each year. And the government receives many, many, many more applications than that every year. So if more applications are received than that each year, then applicants are put on a waiting list for approval for the next year or the next year. So processing times can take several years, because if the United States government has reached its limit for how many U visas it can approve this year, and people are put on a wait list, what happens is the wait list for next year is full, and then the wait list for the next year gets full. So it can take several years for your application to be approved. So during that wait time, you are eligible to apply for work authorization, and you just need to make sure that if you apply for that work authorization, you pay attention to the expiration date and submit an application to renew it 6 months before that application date. Once approved, a U visa is valid for 4 years. After 3 years, you may apply for lawful permanent residency. So after you've had your U visa for 3 years, you can apply for lawful permanent residency for yourself and your family members that you included on the application, and you need to do that before your U visa expires. So make sure that you're paying very close attention to those deadlines, and that you're reaching out, if you're looking for an attorney, that you're starting that search well before these deadlines pop up. Because some attorneys aren't able to take the case if you don't give them enough time to prepare the application before the deadline expires. Some tips and cautions about the U visa process. If your application is denied, you could be referred for removal proceedings, aka deportation. So after your application is denied, you could receive something in the mail called a notice to appear. That basically is assigning you a date at immigration court to appear before a judge for those removal proceedings. So even though a U visa application is a fantastic way to help victims of crime who've been helpful to law enforcement, who may not be eligible for other forms of immigration relief to obtain a status, that's just another reason why I recommend you have an immigration attorney evaluate that case. Because if you're present in the United States right now and you're undocumented and you do not have lawful status, then submitting that application and getting a denial can put you at a greater risk for deportation. Things that make it more likely that your application would be denied or that you would be referred for deportation is if you have a criminal record, or if after receiving your U visa you are convicted of certain crimes. And there are certain crimes that weigh more heavily in the eyes of the government than others. So, for example, crimes that are felonies, crimes involving drugs or substance abuse, crimes that involve harming another person, such as domestic violence or child abuse, as well as crimes they call crimes of moral turpitude. So what moral turpitude means is that it's a crime that makes it more likely that you're a dishonest person. So that is things like fraud, perjury, and in some states, writing bad checks. So those are all things to keep in mind. In one case, I have seen, I had a client who had a lot of traffic tickets, many traffic tickets. And that was someone that got referred for deportation based on their many traffic tickets. Because even though a single traffic ticket is not a big deal and is not typically considered a felony or a major crime, the government decided that the fact that she had received so many traffic tickets in their eyes meant that she had a disregard for the law, because she continued to speed and not wear her seatbelt, even though she had been warned on numerous bases. So that's something to keep in mind. If you retain an attorney to represent you, make sure that you are clear on whether that attorney is representing you just to prepare the application or for the entire process. Attorneys are able to assist you with just part of it, depending on what your agreement and your arrangement is. So because the U visa process can take several years before you find a resolution, many attorneys will agree to help you with preparing the application, but then you're on your own regarding the rest of the application process and have to call them again and rehire them if you receive additional notices in the mail and things that you need help with. So make sure that you understand what exactly that attorney is helping you with and when you should find an attorney or try to get in touch with an attorney if you receive certain documents in the mail. Again, always update your address with your attorney and USCIS, that's immigration. Do not miss your deadline to apply for lawful permanent residency. And just so you know, all forms and instructions on how to fill out the forms are available for free on uscis.gov. You can go to uscis.gov, go to the tab that says Forms, and access, download, and print all of their forms. So if someone is going to charge you a lot of money for those forms but not help you fill them out, etc., just know you can get those for free at uscis.gov. Another note is that make sure if you get someone to help you fill out these forms, make sure that they are a licensed immigration advocate or attorney. There are some folks and businesses out in the United States that, particularly in notary offices and sometimes tax preparation places and insurance places, there will be someone there who says, "Oh, I will help you fill out these forms," and they will print them and get the information from you and fill them out. But notaries, tax preparers, and insurance sellers are not necessarily licensed attorneys, which means they may fill in the blank that says name for you, but they cannot give you legal advice and they cannot evaluate your case. And, that's not giving you any kind of certainty or advice about whether or not you're eligible for that application. So please make sure that the person helping you is not a notario and that they are actually a licensed attorney. Delaying applying may make it less likely that law enforcement will sign your certification. So there is no time limit on when the qualifying criminal activity occurred. But if you want to apply for a U visa now, and the criminal activity that you reported happened 6, 7, 10 years ago, it's possible that when you contact law enforcement, they're no longer going to have the records on your case, or that whoever helped you is no longer working there. So the longer the period of time passes after the crime, the less likely it is that you're going to be able to get law enforcement to sign those forms. And the harder it's going to be to show that you suffered substantial harm. So it's recommended that as soon as you can after the crime occurred, report it and get help preparing that U visa process. Because some people find out about U visas many years. I've had some folks, it'd be 10, 13, 15 years after the crime happened. They find out about U visas and they want to proceed, and that just makes it much more difficult for them to find the records they need, the witnesses they need, and to get law enforcement cooperation with that. Get the help of a victim advocate if possible to help you contact law enforcement about the certification, and remember that all documents submitted must include an English translation. So if people submit statements for you, or if your written statement is in another language, then a certified person, someone qualified that understands that language, is going to need to translate that and include an English translation. The same applies for birth certificates of any qualifying family members. So if you have a marriage license for your spouse that's in another language, or if you have a birth certificate that's in another language, then those are all going to need to include a translation. So I hope this overview was helpful. And please refer back to the beginning of the presentation if you are interested in applying for assistance and applying for services through South Carolina Legal Services to assist you with this application. South Carolina Legal Services does have some limitations on who we are able to assist based on income and based on citizenship status. However, if you are the victim of a crime or a victim of domestic violence, even if you are not a United States citizen, we may still be able to assist you with your application. So please keep that in mind when making the decision to apply, and check out the phone system and online system for the instructions on how to do that at the beginning of this presentation.